A man dropped off a pair of trousers at his local dry cleaner. The owners temporarily lost them. Most people would ask for a refund, but this man wasn't most people. He was a judge. Instead of accepting an apology, he sued the immigrant family who owned the shop for $54 million, completely destroying his own life in the process. The American legal system is built on the principle that any citizen who has been wronged can seek justice in a court of law. It is a beautiful concept, designed to protect the little guy from being crushed by the powerful. But what happens when the law is weaponized? What happens when a man who knows the law inside and out decides to use it to exact personal vengeance over a minor inconvenience? This is the story of Pearson versus Chung, a legal battle that became the international poster child for frivolous lawsuits. It is a story of arrogance, a warning about the limits of consumer protection, and the saga of the most expensive pair of trousers in human history. Our story begins in May 2005 in Washington, D.C. Roy Pearson was a 54-year-old lawyer who had just been appointed as an administrative law judge. By all accounts, Pearson was a man who demanded precision, order, and respect. He was going through a difficult divorce, his finances were strained, and his stress levels were high. To prepare for his prestigious new role on the bench, Pearson decided he needed his suits altered. He took 5 of his suits to Custom Cleaners, a local dry cleaning shop in his neighborhood. Custom Cleaners was owned and operated by Jin Nam Chung, his wife Sue Chung, and their son Ki Chung. The Chungs were immigrants from South Korea who had moved to the United States in 1992 in pursuit of the American dream. They worked grueling hours, saving every penny to open their own small business. They were beloved in the neighborhood, known for their warm smiles and 2 signs hanging proudly in their storefront window. One sign read, "Same-day service." The other read, "Satisfaction guaranteed." To the Chungs, these were friendly slogans. To Roy Pearson, they were binding, ironclad legal contracts. The initial alterations went smoothly. But a few days later, Pearson brought in another pair of pants, part of a burgundy and blue pinstripe suit. He asked for the waist to be let out by 1 inch. When Pearson returned to pick up the trousers, Sue Chung couldn't find them. It was a simple, honest mistake. They had been temporarily misplaced in the racks. Chung apologized profusely and asked Pearson to give her a few days to locate them. If she couldn't find them, she promised to compensate him for the loss. Pearson left the store in a blinding rage. A few days later, the Chungs miraculously found the trousers. They called Pearson to tell him the good news, but when Pearson arrived and inspected the pants, he made a startling claim. He declared that these were not his pants. He pointed to the alteration tags and the stitching, insisting they were imposters. The Chungs were baffled. The tags matched his ticket exactly, but Pearson refused to accept them. Instead, he demanded the Chungs pay him $1,150 for the price of the entire suit. The Chungs, feeling they were being extorted, refused to pay for a suit they had already found. This refusal unleashed a legal nightmare. Roy Pearson didn't just file a claim in small claims court. He filed a massive civil lawsuit in the District of Columbia Superior Court. He decided to base his entire case on the 2 signs in the Chung's window: satisfaction guaranteed and same-day service. Pearson argued that because the Chungs lost his pants and did not satisfy his demands, they were guilty of fraudulent misrepresentation and violating the Washington, D.C. Consumer Protection Procedures Act. When the lawsuit was filed, the public assumed it was a typo. Pearson was suing the family not for $1,000, but for an astonishing $54 million. How does a pair of pants become worth the GDP of a small island nation? Pearson's mathematical gymnastics were terrifyingly methodical. Under the D.C. Consumer Protection Act, a business could be fined $1,500 per violation. Pearson argued that every single day the signs were in the window constituted a separate violation. He counted 12 distinct violations per day, multiplied by the 1,200 days the Chungs had owned the store. That alone totaled $21 million. But he didn't stop there. He added $2 million for emotional distress and mental suffering. He then added $90,000 for car rental fees. He claimed that because he could no longer trust the Chungs, he would need to rent a car every single weekend for the next 10 years to drive to a different dry cleaner outside of his neighborhood. Finally, he added hundreds of thousands of dollars in legal fees, even though he was representing himself. The grand total was $54,272,200. The media caught wind of the lawsuit, and it exploded into an international circus. News crews surrounded the tiny dry cleaning shop. The public was outraged. The American Tort Reform Association called it the most abusive lawsuit in the history of the country. The Chungs were terrified. They didn't understand how their new country could allow a judge to destroy their lives over a pair of found pants. The legal fees to defend themselves were mounting so rapidly that they considered declaring bankruptcy and fleeing back to South Korea. Fortunately, public sympathy led to the creation of a legal defense fund, which raised thousands of dollars from ordinary citizens to help the family hire a high-profile attorney, Chris Manning. In June 2007, the trial finally began. The courtroom was packed with journalists from around the world. What they witnessed was surreal. Roy Pearson, acting as his own lawyer, took the witness stand. During his testimony, when recounting the moment he realized his pants were missing, this sitting judge broke down. He openly wept in the courtroom, dabbing his eyes with a tissue as he described the profound emotional trauma of losing his trousers. The defense strategy was simple and devastating. Attorney Chris Manning argued that satisfaction guaranteed is a standard retail promise, not an unconditional surrender to the unreasonable demands of a single irrational customer. A reasonable person does not expect a business to pay $54 million for a delayed alteration. Manning also called witnesses who testified that the pants the Chungs found were, without a doubt, Pearson's original pants. On June 25, 2007, Judge Judith Bartnoff delivered her verdict. It was a sweeping, absolute victory for the Chung family. She ruled that Pearson was entirely unreasonable. She stated that satisfaction guaranteed does not mean a consumer can extort a merchant. She dismissed all of Pearson's claims and ordered him to pay the Chungs' legal fees, which amounted to tens of thousands of dollars. But the tragedy of the story is the aftermath. The Chungs had won, but the stress of the international media spotlight and the years of litigation had broken them. Shortly after the verdict, they closed Custom Cleaners and sold the business. The American dream had turned into a nightmare of endless paperwork and anxiety. As for Roy Pearson, his hubris proved to be his ultimate downfall. He refused to accept the verdict and filed multiple appeals, all of which were rejected. But his actions had caught the attention of the Judicial Review Board. When Pearson's term as an administrative law judge expired, the board refused to reappoint him. They determined that his lawsuit demonstrated a severe lack of judicial temperament, judgment, and ethics. He lost his highly paid, prestigious career. The case of the $54 million pants remains one of the most infamous legal battles in modern history. It is taught in law schools as a prime example of the abuse of process. It stands as a powerful reminder that the scales of justice are not meant to be used as a weapon of petty revenge, and that sometimes the price of refusing to let something go is losing everything you have.